Hello, everyone. I think we're going to begin. There may be some conference stragglers still coming in. We'll excuse them for being late. Thank you, everyone, for being here. My name is Elliot Kim, and I'm a 2L here at Harvard Law School. I'm a member of APALSA, and we're very excited for this event, the HLS trial reenactment. This is our second year doing it, and we're very excited for this. I'm going to introduce Dean Sells, who's going to say a few words. The reenactment will go about an hour, and then we'll have a Q&A for about 20 minutes. Dean Sells.
Hi, I'm very excited to be here for a second year for the APALSA conference, which now is in its 24th anniversary. I'm very excited about us recreating another presentation that helps bring law to life and people to understand issues, and very excited on behalf of the law school to welcome all of you here for this amazing conference and then for the reenactment. I congratulate all the students from APALSA who helped to make this event possible. I know how many hours go into that, so I also would like to encourage a round of applause for the students and all of their work. And without further ado, the reenactment.
It is March 20, 1944. Takeo Ishikawa is sitting alone at a desk at the Heart Mountain Relocation Center in Wyoming. He has finished writing a letter to his local draft board in Palo Alto, California.
Dear Sir, on March 5th, 1944, I received my pre-induction physical notice stating that I was to report on the morning of March 8th to Powell, Wyoming. I did not report, not because I am trying to evade the draft, but because of my firm conviction that what the government is doing and already has done is wrong, and that our status should be fully clarified prior to our induction into the armed forces. I was born in the small town of Mountain View, California. I attended public school, where we were taught to believe in the Constitution of the United States and the Bill of Rights, and that these instruments would apply to the minority groups. This was the land of the free, a democracy, and the laws governing this nation would apply to any individual regardless of race, color, or creed. And then, on December 7th, 1941, the so-called sneak attack on Pearl Harbor was perpetrated. We lowly individuals of Japanese descent were as unaware of any such plot to attack as were our American neighbors. Outraged by the deed, many of us, to show our sincerity and loyalty, bought war bonds, joined Red Cross units, and donated sums of money, became blackout wardens whenever allowed, and so forth. Many of the Nisei boys volunteered for the armed forces, but were rejected on account of our racial background. For us, life changed overnight and became a nightmare. Fear obsessed us. Our bank accounts and assets were frozen. A curfew was placed on us. Our fathers were interned, rudely snatched away from their families. Finally came our evacuation proclamation from the President and the utterance from General DeWitt that
a Jap is a Jap.
We were not accused of any crime or charged with any seditious act or sabotage. Without any trial, we were ordered to leave our homes. We were uprooted from everything we held dear and near to us: our homes, friends, and fortune. On May 26, 1942, my aged mother, my sister, and I left Mountain View for the famed Santa Anita horse tracks. We were number 32013. That was our number and still is. We were no longer individuals in an upright society, but merely numbers, the same as any convict. After 3 long months, we were transferred here to Heart Mountain. In our present status, we are not free citizens. As a limited rights citizen, I protest my drafting into the Selective Service. I want to be a free citizen, enjoying full citizenship status, enjoying all the rights and privileges of an American citizen before I enter the military service. I sincerely hope for a better clarification, and until such time, I do not intend to report. But, if necessary, I will contest in the courts the legality and constitutionality of the selective service as it pertains to the Nisei. Sincerely yours, Takeo Ishikawa.
Only a matter of months later, on the morning of May 15, 1944, Takeo Ishikawa stood before a federal judge and, with 62 other Japanese-American prisoners from the Heart Mountain concentration camp, pleaded not guilty to violations of the Selective Service Act of 1940 for failure to report for pre-induction physical examination. Our presentation today will tell the story of Mr. Ishikawa and the other draft resistors from Heart Mountain based on records of the court proceedings and other contemporaneous documents. Mr. Ishikawa's letters were included in the Record on Appeal to the 10th Circuit as generally reflective of the views and experiences of all the defendants.
The Japanese attacked Pearl Harbor on December 7, 1941. In the next 3 days, the FBI arrested nearly 1,300 Nisei, first-generation Japanese immigrants in Hawaii and the western states. These were the fathers described as snatched away in Ishikawa's letter. Under the law at the time, they could not be naturalized as U.S. citizens because of their race. The children of the Nisei, had been born in this country. By virtue of the 14th Amendment, they were U.S. citizens. While shocked by the arrest of their parents, the Nisei believed that they would be treated differently.
They were mistaken. On February 19, 1942, President Roosevelt signed Executive Order 9066, authorizing military authorities to designate military areas from which any or all persons might be excluded. Shortly thereafter, General John DeWitt, Commanding General of the Western Defense Command, issued Public Proclamation No. 4, forbidding any person of Japanese ancestry in parts of California, Oregon, Washington, and Arizona to leave their areas without military permission. In his report recommending removal of all Japanese Americans from these areas, he stated his views mirroring those of politicians and newspapers of the time. Here are General DeWitt, a politician and a newspaper columnist.
The Japanese race is an enemy race. All members of that race are potential enemies. Even if Americanized, their undiluted racial strain makes their removal from the vital Pacific coast absolutely necessary. The fact that no sabotage has yet taken place only makes it more likely that such action will be taken.
I join the elected representatives from the other Western states when I demand that all Japanese, whether citizens or not, be placed in inland concentration camps. Why, if an American-born Japanese is really patriotic, this is his opportunity. He can permit himself to be placed in a concentration camp.
Just to be clear for all my readers, we should just move them to the Badlands. I hate the Japanese, and that goes for all of them.
By the end of March 1942, Japanese American families were being told to prepare for removal from the designated areas and that they could bring with them only what they could carry. When they reported as ordered, they were given numbers and moved to so-called assembly centers, which included horse stables at racetracks. Some 120,000 people, nearly two-thirds of them U.S. citizens, spent the summer of 1942 in these centers, located mostly in California, as the federal government prepared 10 concentration camps in more remote areas in other states. The governors of these states were asked for their input. Chase Clerk, then governor of Idaho and later a federal judge, made his position clear.
I want to admit right on the start that I am so prejudiced that my reasoning might be a little off because I don't trust any of them. So they're not coming to Idaho unless certain conditions are met. And one of them is that any Japanese sent to Idaho must be placed under guard and confined in concentration camps for the safety of our people, our state, and the Japanese themselves.
The Japanese American families in the assembly centers were herded onto trains and shipped to the camps in the late summer and early fall of 1942. They went quietly, with many apparently adopting the attitude of the Japanese American Citizens League, the JACL, an organization created by Nisei in 1930 to advance the interests of Americans of Japanese descent. The JACL president, Saburo Kido, stated the group's position as follows.
We are going into exile as a duty to our country because the president and military commanders in this area have deemed it necessary. What greater love, what greater testimony of one's loyalty can one ask for than this? Leave your homes, your businesses, and your friends in order that your country may better fight a war.
6 months later, the JACL convened a conference to discuss cooperation with the War Relocation Authority. Delegates were selected by the JACL and granted furloughs from their camps. Mike Masaoka asked them to endorse the JACL's latest effort to prove Japanese-American loyalty.
It was a proud time for us when this nation's first peacetime draft in 1940 called upon us to serve. 3,500 Nisei were drafted in the first year. It was humiliating when, in the wake of Pearl Harbor, we were reclassified as aliens, ineligible for the draft. We are being deprived of our biggest chance to prove our loyalty. Somewhere on the field of battle, in a baptism of blood, we and our comrades must prove to all who question that we are ready and willing to die for the one country we know and pledge allegiance to.
The delegates passed a resolution asking the federal government to reclassify the Nisei as draft eligible. The Office of War Information suggested instead a volunteer Nisei combat team based upon an individualized test of loyalty. Shortly thereafter, President Roosevelt announced his approval of the new all-Nisei unit, the 442nd Regimental Combat Team. Mike Masaoka, called to the Pentagon to receive the news, was disappointed, but he volunteered to become the first member of the unit. The loyalty questionnaire that was distributed at the concentration camps, as well as this concept of a segregated combat unit, only added to the dismay of Japanese Americans who had been less than enthusiastic about the JACL resolution in the first place.
Both the JACL and the officials at the Pentagon continued to press for reinstitution of the draft into integrated units. For the Pentagon, integration was a problematic issue, in part because African Americans were only allowed to serve in segregated units. Finally, in December 1943, the War Department determined to reinstate the draft for Nisei into segregated combat units. On January 20, 1944, the War Department announced that the Nisei would be reclassified by their selective service boards and called for induction if physically qualified.
The populations of the different camps reacted in different ways, some with violent outrage, while others sent large numbers of volunteers. At the Heart Mountain Camp, located 60 miles east of Yellowstone National Park in northwest Wyoming, 55-year-old Kiyoshi Okamoto started writing about the injustices of detention. This led to the creation of the Fair Play Committee, a collective effort by detainees at Heart Mountain to openly resist the draft. The FPC spread its message through bulletins and public meetings, which became increasingly popular, in part because of Okamoto's blunt and fearless style. The FPC carefully limited its membership to Japanese American citizens who professed loyalty to the United States and were willing to serve in the military once their civil rights were restored.
The FPC's first public meeting on February 8, 1944, was attended by 60 Nisei. More meetings followed. As the FPC gained momentum and support, its voice became louder and more direct. One of the newspapers that supported the FPC was the Rocky Shimpo, a newspaper based out of Denver, Colorado, that served the Japanese American community and was widely read at Heart Mountain. Jimmy Omura, the Shimpo's English language editor, printed news that reported favorably on the FPC's activities and editorials that questioned the lawfulness and propriety of the draft. On March 1, 1944, the FPC leaders distributed a bulletin that described their attitude toward the draft.
The FPC believes we have a right to ask that the discriminatory features in regards to this selective service be abolished, our status be clarified, and our rights be fully restored before we are drafted.
A few days later, the group went further.
We, the members of the FPC, are not afraid to go to war. We are not afraid to risk our lives for our country. We would gladly sacrifice our lives to protect and uphold the principles and ideals of our country as set forth in the Constitution and the Bill of Rights. But without any hearings, without due process of law, without any charges filed against us, without any evidence of wrongdoing on our part, 110,000 innocent people were kicked out of their homes, literally uprooted from where they have lived for the greater part of their life and herded like dangerous criminals into concentration camps with barbed wire fences and military police guarding it. And then, without rectification of the injustices committed against us and without restoration of our rights as guaranteed by the Constitution, we are ordered to join the Army through discriminatory procedures into a segregated combat unit. We, the members of the Fair Play Committee, hereby refuse to go to the physical examination or to the induction if or when we are called in order to contest the issue.
Within days, 5 Nisei refused to get on the bus for their pre-induction physicals, and 2 days later, 7 more. Alarmed, camp officials reached out to the Department of Justice and the War Relocation Authority. They held leave clearance hearings for 2 of the FPC's leaders, even though neither had applied for leave, and ordered them transferred to another camp. U.S. Marshals arrested and jailed the first 12 Nisei who had refused to get on the bus for their pre-induction physicals. Nevertheless, more young men refused to report. By the end of March 1944, 41 were in Wyoming County jails, and Jimmy Amaura, the Denver newspaperman, was forced to resign. His newspaper was told that it would be closed unless Amaura was removed as English language editor.
2 indictments were filed with respect to the Heart Mountain draft resistors, resulting in 2 trials. The first was United States versus Fujii, which would become known as the mass trial, as 63 draft resistors from Heart Mountain would be tried together on the charge of evading the draft. The second was United States versus Okamoto, which would become known as the conspiracy trial, as 7 of the FPC leaders at Heart Mountain would be tried together for conspiracy to counsel, aid, and abet the Heart Mountain draft resistors. The government charged an 8th defendant with conspiracy, Jimmy Omura. He had never met any of the resistors, but was indicted solely on the basis of his newspaper columns.
The mass trial commenced on Monday, June 12, 1944. The government was represented by Carl Sackett, the United States Attorney for the District of Wyoming. The FPC hired Samuel Menon, a prominent civil rights lawyer from Denver, to represent all 63 defendants. One of Menon's first decisions was to waive the defendant's right to a jury, a sensible tactic given the jury pool in Cheyenne, Wyoming. This meant, however, that the fate of the 63 men was entirely in the hands of Judge T. Blake Kennedy, who had been the sole federal judge in the District of Wyoming for over 20 years. Judge Kennedy's view of the defendants was apparent from day one, when he addressed the 63 defendants in open court as,
You, Jap boys.
The government strategy was straightforward. It only had to prove that the defendants received notices but failed to report for a pre-induction physical exam, facts that were not contested. In contrast, Menon sought to paint a broader picture of injustice and unfairness by eliciting testimony as to the defendants' loyalty to the United States, their loss of freedom, and their willingness to serve in the Army once their rights had been restored. Menon also tried other tactics, such as having the defendants give themselves similar haircuts, crew cuts, and then arguing that the charges should be dismissed because the agents could not tell the defendants apart. Judge Kennedy quickly rejected this argument, ruling that the defendants had identified themselves when they were arrested and admitting in evidence their fingerprint cards as proof of identity.
The government called to the stand the clerk of the local draft board, who identified the paperwork proving that the defendants refused to report for their physicals, and also called the FBI agents who had interviewed the defendants. One of them was FBI agent Harry McMillan.
Please describe your investigation in the case regarding Yoshito Kuromiya, including any details of any interview you had with the defendant.
I interviewed the defendant on April 6, 1944, at the county courthouse in Cody, Wyoming.
Would you please state what you advised him with and so forth?
I asked him first to give me his name and address. I gave the defendant my name, advising him that I was with the FBI and that I wanted to talk to him. I told him the interview was to be used in court proceedings. I further advised him it was his privilege to not say anything concerning the matter, and I asked him if he had any objections to an interview in that regard, and he said no. And we went on with the interview. He gave his age as 20.
Had he been arraigned?
Yes, sir. He gave his age as 20, being born on April 23, 1923, at Sierra Madre, California. He produced his registration card, and he gave his local board number as 192 at Pomona, California. He came to the Hart Mountain Relocation Center in August of 1942, and there he received first a 4C classification card from his local board, and then a 1A classification card. He said he received his pre-induction physical examination notice. He advised me that he did not report as ordered. I then asked him to briefly give his reasons for not reporting for his pre-induction physical examinations, and he replied,
It was not fair. The government treated me as if I were disloyal, without even questioning me or asking me anything about it. The way I was treated, it was not constitutional. If I did not protest, I would be just as responsible as those who made the decision. A citizen who will accept bad government without protest is not a good citizen. I would willingly go to the Army if these matters were cleared up to my satisfaction.
Menon cross-examined.
Now, in your interview with this defendant, Kuromiya, wasn't he courteous to you?
That is correct.
And his entire attitude towards you was that of desiring to be loyal to the government, wasn't it?
That's right, Mr. Menon. All these gentlemen who I interviewed here were courteous and treated me very nicely, as I treated them. And at no time was there any act, or did they say anything against the United States or indicate any disloyal attitude.
At no time did they indicate any desire to go back to Japan?
That's right.
Throughout the entire interview with this particular defendant, he indicated a desire to fight for this country if he were restored his rights as a citizen?
I presume so. There was not one of them who did not.
The government also called to the stand Douglas Todd, the assistant project director at Hart Mountain.
Director, was transportation available for these 63 defendants to be taken to the Powell Board?
It was.
Was there any restriction in the center prohibiting any of these 63 defendants from going to the Powell Board and reporting in accordance with the motion received?
No, there was no restriction.
On cross, Todd resisted the notion that the defendants' rights were curtailed at Hart Mountain.
Is the Hart Mountain project patrolled by military police?
No, I wouldn't say it was.
Is it guarded by military police?
There are military police there, yes.
And they are there for the purpose of guarding the project, are they not?
Their function has to do with the Army. I am not able to say.
Now, have any of the persons who are confined at Hart Mountain been sent there for violation of the law?
I don't know.
Do you know why they were sent there?
No, I do not.
But do you know that there are those there who are restrained of their liberties within the confines of this area?
I don't think they are restrained of their liberties. They are not restrained in any sense.
What would happen to an evacuee if he would attempt to leave the center without obtaining a permit?
That relocation center is a military reservation. The government is feeding the people and housing them, and they would naturally be expected to comply with such rules and regulations as were set up.
Well, suppose a person is living at the Hard Mountain Center. He is supposed to confine his movements within the barbed wire enclosures. Is that correct?
No, that is not correct.
How would it be possible for him to leave the barbed wire enclosures?
The barbed wire enclosure is only a small part of the project, and the people who live there have the freedom of the area outside of the barbed wire, which is some 20,000 odd acres.
But they must be within the confines of these limits. Is that right?
That is right, without a pass.
Director, do you know whether any of these 63 men were ever denied the right to leave the camp, to work, or to be relocated in any place?
I have no knowledge of them ever being denied such right. Our main job up here is to get them out of that center and relocated.
So where are they permitted to go in the U.S. if they want to relocate themselves out of the center?
The Western Defense Zone includes parts of the states of Washington, Oregon, California, and Arizona. They are excluded from there, of course, in the evacuation, and they have not been permitted to return there except for very few people.
Is a Japanese American citizen required to have a travel permit outside of the center?
To leave the center, he is required to have what we call an indefinite pass.
And any Japanese American citizen who obtains a pass to leave the center, as I understand it, can travel without a travel permit in any of the areas which are not in the war zones inscribed?
That is correct.
The same as any other citizen?
That is correct.
The defendants did not call any witnesses and rested at the close of the government's case. In his summation, Menon argued,
placing American citizens in relocation centers was something Hitler would do.
Sackett responded with outrage and in a very personal manner.
The defense counsel has compared the system of relocation to something Hitler would do, and I resent that. These men and their families have been housed, clothed, fed, and schooled by the federal government, perhaps better than the court when he was a young man, and I know better than I was. When the Jews were kicked out of Germany, they were left to shift for themselves. But our government cared for these men and their relatives. The defendants are using my money, your money, everybody's money by having this trial, by saying they were not fight for this country. They want their freedom, they say. Do they want their freedom so that they can go out and signal the Japanese submarines? They all admitted they are loyal American citizens. Is that a cloak back of which to hide or an excuse to get away from the draft?
On Monday, June 26, 1944, after 6 days of trial, Judge Kennedy announced his decision. He addressed the defendant's claim of discrimination, citing the Supreme Court's decision in Hirabayashi v. United States, decided in 1943.
The defendants assert that as American citizens by birth, they have been discriminated against by various acts of the government. Defendants assert that they should not be reclassified for service in the war, at least until such time as their status as citizenship has been clarified. That the regulations promulgated by Congress and the President are legal has been definitely determined in Hirabayashi versus United States. There, the matter litigated was the constitutionality of the establishment of a curfew law in which all Japanese American citizens were required to report and be restricted to their residences during certain hours of the day. The Supreme Court based its conclusion on the exigencies of war between the United States and the Japanese nation, calling attention to this sneak attack upon Pearl Harbor, with an observation that Japanese diplomats were at the same time negotiating with the State Department to settle differences between the two countries. The Supreme Court also noted that the Japanese government recognized a dual citizenship and maintains that children of Japanese nationals are citizens of the Japanese Empire, wherever their place of birth, even among persons of Japanese ancestry born in this country, and therefore are citizens of Japan. That there might be logic in the conclusion that in a case of war, these individuals would hold their attachments to Japan, and in a critical hour, these cannot be effectively segregated so as to relieve a menace to the national defense and safety.
The Supreme Court had not yet decided Korematsu. Judge Kennedy foresaw that such a constitutional challenge to the removal, relocation, and confinement of Japanese American citizens would be defeated.
It would seem that the same logic, which led to the conclusion that the curfew law did not violate the constitutional rights of citizens of Japanese extraction, would justify a like conclusion in regard to removal and relocation. The discrimination exercised by the government on account of defendants' Japanese ancestry was legitimate, justified, and legal, and within the power of Congress and the President in the war emergency. Defendants' assertion that they did not desire to report until their citizenship had been clarified is without merit as to legal basis. It is evident that what they asserted in the matter of the clarification of their citizenship was in fact accomplished by the effect of the order which they disobeyed. When they were placed in 1A in order to report for pre-induction physical examination, their pure American citizenship was established beyond question.
Indeed, as Professor Eric Muller has noted, the defendants were free to die for their country, but not free to enjoy the same rights and privileges as other citizens. Judge Kennedy concluded as follows.
Personally, this court feels that the defendants have made a serious mistake in arriving at their conclusions which brought about these criminal prosecutions. If they are truly loyal American citizens, they should, at least when they have become recognized as such, embrace the opportunity to discharge the duties of citizens by offering themselves in the cause of our national defense. The finding and verdict of the court is that each of the defendants is guilty as charged in the indictment. It is the sentence and judgment of this court that you and each of you shall be committed to the custody of the Attorney General for confinement in such institution as he may select for a period of 3 years. The defendants are all committed to the custody of the United States Marshal.
The government prosecuted the 7 leaders of the Heart Mountain Fair Play Committee, as well as Jimmy Amaura, for conspiring to counsel, aid, and abet the draft resistors. Judge Eugene Rice, visiting from the U.S. District Court for the Eastern District of Oklahoma, presided over the trial. A.L. Weirin, a civil rights attorney from Los Angeles, represented the FPC leaders. Sidney Jacobs, a Denver attorney, represented Omura. The U.S. Attorney for the District of Wyoming, Carl Sackett, and Assistant U.S. Attorney John Pickett appeared for the government.
Defendants submitted 2 motions to quash the indictment. The first challenged the composition of the grand jury on the grounds there were no Japanese grand jurors, and the second argued that the defendants were being detained in violation of their right to due process of law. The court held a hearing on both motions on August 5, 1944.
Not even one American of Japanese descent served on the grand jury, despite the fact that nearly 5% of Wyoming's population is now Japanese because of Heart Mountain. Defendants' constitutional rights were therefore violated, and we moved to quash the indictment.
What do you have to say about this, Mr. Sackett? Can you stipulate to that?
Your Honor, no Japanese or American of Japanese descent was on the grand jury to my knowledge at this time. That's a fact. But certainly it is not to be presumed that this court exercised in any unfairness in drawing a grand jury among citizens of the United States.
Will you stipulate that there has never been, in this district, an American of Japanese ancestry on a jury?
No, I don't know, so I wouldn't. I have known Japanese to be on trial juries. I have tried cases where Japanese were on the jury. On this particular grand jury, no person of Japanese descent was drawn unless the resemblance was slight and I didn't observe it. But that doesn't bind the court.
Your Honor, we had some difficulty in reaching a stipulation, so apparently it's necessary that we introduce evidence on this question. I would like to call the clerk of the court, Charles J. Ownhouse.
So be it.
You're the clerk of the court, sir?
Yes.
For how long have you been the clerk?
Since November 1909. Before that, I was deputy clerk since May 1901.
During the time in which you acted as either clerk or deputy clerk, to your knowledge, has any Japanese person or American of Japanese ancestry been a member of any grand jury?
I wouldn't want to say definitely without searching the records. I have no recollection of any American of Japanese descent ever sitting on a grand jury.
Mr. Ownhouse, has the court ever adopted any rules prohibiting an American of Japanese ancestry from sitting on a grand jury?
No.
Do you know whether or not there were any names of persons of Japanese ancestry in the jury box from which the names were drawn?
I couldn't say definitely about that either.
Would you know whether the number of citizens of Japanese descent in the state of Wyoming is large or small?
My opinion is that it is very small.
Prior to the time that these Japanese were located in the state of Wyoming at this place, Heart Mountain, how many Japanese were there in the city of Cheyenne?
You mean American?
Born in the United States.
I couldn't definitely say. A very small number.
Has there been any intentional omission of citizens qualified as jurors of Japanese descent from the jury panel?
There has not.
The witness is excused. I am going to overrule the motion to quash at this time. These Japanese who have been brought into the state of Wyoming, probably against their will, are probably not qualified to act as grand jurors because they are not residents of the state. They are temporary residents. And prior to that time, I don't think there was anything that would require that a Japanese person be on the grand jury or on the jury panel. No substantial showing has been made that there were many Japanese in the state of Wyoming, or that there was any system of exclusion of that particular group of jurors from the jury box by reason of their nationality. On the motion to quash on the ground that defendants were, at the time of the indictment, and are still, deprived of their liberty without due cause of law, have you reached an agreement on the facts?
No, Your Honor.
If you cannot agree, Mr. Weirin, you may put on your evidence.
The defense calls Defendant Frank Seshi-Emi to the stand.
Frank Emi was one of the leaders of the FPC. He had been a successful grocer in Los Angeles until he was detained and relocated to Heart Mountain. At Heart Mountain, he drove a truck and made tofu for other detainees.
What is your name?
Frank Emi.
You are now in Wyoming County Jail?
Yes, sir.
Where were you before you came to the county jail?
At Heart Mountain.
For how long?
Since September of 1942.
And very briefly, how did you arrive and why did you go?
Prior to that, we were at the Pomona Assembly Center where we were evacuated from our homes.
Where was your home?
Los Angeles.
You were evacuated under military order?
Yes.
Sometimes this year, did you attempt to walk out of the relocation center?
Yes, on March 29th, 1944.
And what happened?
When the draft was instituted and I learned I was eligible for it, I figured I was now recognized as an American citizen. So I walked out of the center with Hirino and Demisa. An armed military police officer stopped me and said he would arrest me if I walked out without a pass. I asked him, if I was an American citizen, didn't I have the right to the freedom of movement? He said no. He said he had orders to arrest me. I said, suppose I resisted. And he said he would have to use force, which I thought implied using his gun. After I was arrested, I was put in the MP guardhouse, and the guard again told me if I tried to get away, I would be shot.
Mr. Emi, Heart Mountain is a rather large establishment, isn't it?
Yes.
And there is nothing around it but an ordinary barbed wire fence, right?
There is a barbed wire fence and guard towers.
You can get outside through the gates all around.
No.
Isn't there a rather large portion of land that is farmed outside of the fences?
I think so.
Can't people in Heart Mountain go out there to work and raise their crops?
Only with special passes.
Anybody who wanted to work had a pass, right?
No.
Have you ever been able to leave Heart Mountain to work?
I believe one time a farmer requested my services during a beet harvest, and I was given a special pass.
How often did you leave to work?
I have never been out of there except that one time on a special pass.
Because of your conduct.
They have a stop list there.
Were you on the stop list because of your conduct?
I have never broken any law except when I walked out of there.
Were you ever refused a permit to get out of there and go to work?
Yes.
Do you know of anyone else who was refused a pass to leave and go to work, except these defendants?
There were quite a few.
Judge Rice denied defendant's second motion to quash as well, refusing to find the detention unconstitutional. The case proceeded to trial on October 23, 1944. The defense called Minoru Demisa, an oyster farmer and mill worker from the Seattle area, who was one of the leaders of the FPC.
Mr. Demisa, have you ever complied with orders from your local draft board?
Yes.
When?
Before Pearl Harbor. I was born and raised in a typical American community on the outskirts of Seattle, Washington. I grew up with some nice neighbors. When I was living there, I received a draft notice to report for a physical examination, and I did. To protect the security and happiness and freedom of my life there, I was willing to serve my country.
Have you ever not complied with draft orders?
Yes.
When?
After Pearl Harbor. We were evacuated from Seattle to a concentration camp. I received the order from Heart Mountain. It seemed to me that the Selective Service didn't mean for me to fight to protect the security and freedom of a barracks room in a concentration camp, or to go to war while my family was still imprisoned in the camp, so I didn't report.
Mr. Demisa, are you a member and a leader of the Fair Play Committee, the FPC?
Yes.
What is the mission of the FPC?
To air grievances, improve the situation of those interned, and test the constitutionality of the evacuation.
What do you mean by that, to test the constitutionality of the evacuation?
We wanted to create a test case for the courts. We wanted the government to clarify our citizenship rights before we joined the military. We thought it was unconstitutional for the government to imprison us and strip us of our rights while simultaneously drafting us to serve and fight for this country. We were willing to serve as soon as our rights were restored.
Mr. Demisa, does this document look familiar to you?
Yes, it is one of the FPC's publications.
Could you read the highlighted text?
It says, "We, members of the Fair Play Committee, hereby refuse to go to the physical examination or to the induction if or when we are called in order to contest the issue. We hope that all persons whose ideals and interests are with us do all they can to help us."
So, Mr. Demisa, did you and the leadership of the FPC encourage others at Heart Mountain to evade the draft?
Yes, but...
Nothing further.
Following closing arguments, counsel presented their jury instructions to the court. The Second Circuit had recently upheld a trial court's determination that the desire to test the legality of laws discriminating against a pro-German organization was not a defense to charges of draft evasion. The Keegan case was set for oral argument before the Supreme Court as Weirin prepared his jury instructions. Looking ahead to the appeal and hoping that the Supreme Court would reverse the Second Circuit, Weirin requested a test case jury instruction.
We request that the court instruct the jury to determine whether the defendants acted in good faith or in bad faith, and to consider the sincerity or the insincerity of the defendant's belief that the citizenship status and the rights of American citizens of Japanese descent evacuated from the Pacific Coast and detained at Heart Mountain Relocation Center could be lawfully determined or clarified by the courts upon prosecution for their refusal to comply with the draft. If the jury finds that the defendants sincerely and in good faith entered such a belief, they should acquit.
Any objections?
The government objects, Your Honor. The test case defense is without merit. That said, the government would not object if the court instructed the jury to consider all the evidence in the case, including any evidence as to the test case, which might indicate that the defendants did not, in fact, knowingly conspire together to counsel evasion.
Both proposed jury instructions are denied. Instead, I will instruct the jury as follows. A desire to have a test case does not excuse failure to comply with the Selective Training and Service Act. It is a violation of the law for anyone to counsel another to disobey the draft law, or to assist or abet one to evade the draft law. And I charge you that it is a violation of the law. even though it is contended that the purpose was to create a case for the testing of the constitutionality of the law.
On November 1st, 1944, Judge Rice submitted the case to the jury. After a short deliberation, the jury returned a verdict convicting all 7 leaders of the FPC of conspiracy. Jimmy Amaura, the newspaper columnist, was acquitted. The next day, Judge Rice sentenced the 4 defendants he saw as the most culpable to 4 years imprisonment. He sentenced the others, whom he concluded played lesser roles, to 2 years imprisonment. All 7 were sent to the maximum security federal prison at Leavenworth, Kansas.
The draft resistance movement at Heart Mountain has been described by scholars as the most articulate reaction recorded to the issues facing the detainees at the 10 concentration camps. Other cases were brought, with results that varied little from the Heart Mountain experience. Chase Clark, the governor of Idaho, who had demanded concentration camps for any Japanese coming to Idaho, was the federal judge who tried the resistors from the Minnedoka Relocation Center. When one of the resistors moved to quash the indictment on the grounds that incarceration rendered unconstitutional the government's attempt to draft him, the court denied the motion without recorded opinion and proceeded to conduct 33 separate jury trials over the next 11 days. The jury for each was selected from a pool of 34 Idaho citizens, so that some jurors sat on as many as 11 cases. One lawyer protested, but Judge Clark overruled his concerns. At sentencing, those who had entered guilty pleas received 18 months in prison, while those who went to trial received 3 years and 3 months and a $200 fine.
Some resistors in other camps did fare better in the courts. Approximately 100 resistors from the Poston Relocation Center in Arizona were tried and found guilty, but the judge did not send them to jail and fined each defendant 1 penny. And remarkably, one federal judge simply dismissed the charges against the resistors before him on due process grounds, at some personal risk. The Honorable Louis E. Goodman of the Northern District of California was relatively new to the bench when he traveled from his chambers in San Francisco in July 1944 to Eureka to hear the case of the resistors from Tule Lake. Eureka had been well known for its anti-Asian sentiment since 1885, when all Chinese were expelled from the county and banned forever. Not surprisingly, when Judge Goodman appointed 2 local attorneys, their defense consisted of entering guilty pleas for their clients. After questioning the defendants himself, Judge Goodman decided to call on another attorney, a friend from San Francisco, to represent them. The new attorney moved to withdraw the guilty pleas and then to quash the indictment. Laboring on a Friday evening in a town without a law library, Judge Goodman and his law clerk put together an opinion and packed their bags for a quick getaway, fearing a lynching. With their car idling outside the courtroom, Judge Goodman read his opinion from the bench on Saturday, July 22, 1944.
It does not follow that because of the war power may allow the detention of defendant at Tule Lake, the guarantees of the Bill of Rights and constitutional provisions are abrogated by the existence of war. It is shocking to the conscience that an American citizen be confined on the ground of disloyalty and then, while under duress and restraint, be compelled to serve in the armed forces or be prosecuted for not yielding to such compulsion. The issue raised by this motion is without precedent. It must be resolved in the light of the traditional and historic Anglo-American approach to the time-honored doctrine of due process. It must not give way to overzealousness in an attempt to reach, via the criminal process, those whom we may regard as undesirable citizens. The motion to quash the indictment is granted, and the proceeding is dismissed with respect to the defendant Kobawara and the 25 other defendants similarly charged.
The government chose not to appeal Judge Goodman's decision. and it was therefore never reversed. In affirming the conviction of the Poston resistors, however, the Ninth Circuit noted that wherein the reasoning of the Kuwabara opinion differs with that of this opinion, it may be taken that we are not in accord therewith.
Meanwhile, the Heart Mountain resistors appealed to the 10th Circuit in Denver. They gathered funds to hire Menon to argue the case. Fujii was the named resistor, but by stipulation, all 63 of the convicted resistors agreed that their convictions would be controlled by the outcome of Fujii's appeal. Menon argued to the 10th Circuit.
Can the government do no wrong? Can it subject its people to a loss of civil rights and property without due process of law and at the same time require compliance with the Draft Act? What then would the Nisei be drafted to fight for? So that their parents, sisters, and brothers may continue to remain behind barbed wire under military guard? If our government cannot trust American citizens of Japanese ancestry so that we can accept them on an equal basis and accord them equal rights, then how can we ask them to fight? And for what do we ask them to fight? Is it to fight for a continuation of relocation centers with armed guards and barbed wire? How can we ask them to lay down their lives in approval of such unconstitutional treatment?
In an opinion written by Judge Walter Huxman, the 10th Circuit rejected Menon's arguments and affirmed the resistors' convictions.
Fujii was loyal to the United States at all times. There can be no question about this. He indicated no desire to live in Japan. He wanted to fight for this country if his rights as a citizen were restored. Fujii's entire appeal is predicated on the argument that his confinement behind barbed wire in the relocation center without being charged with any crime deprived him of his liberty and property without due process of law, and therefore he should not be required to render military service until his rights were restored. Fujii could have secured his complete release from the relocation center at any time by writ of habeas corpus. This would have restored his freedom and cleared his name. But this he did not do. Instead, he chose to disobey a lawful order because he claimed his rights had been invaded. Two wrongs never make a right. One may not refuse to heed a lawful call of his government merely because in another way it may have injured him. Fujii was a citizen of the United States. He owed the same military service to his country that any other citizen did. Neither the fact that he was of Japanese ancestry, nor the fact that his constitutional rights may have been invaded by sending him to a relocation center cancel this debt. The judgment convicting the 63 Heart Mountain draft resistors is affirmed.
The defendants who had been convicted in the conspiracy trial also appealed. By the time Weirin argued the appeal to the 10th Circuit, the importance of the instruction he had requested at trial was clear. As he had hoped, the Supreme Court had reversed the Second Circuit and upheld the test case defense. On December 26, 1945, in an opinion written by Judge Sam Bratton, the 10th Circuit reversed the judgments of conviction and remanded the cases to the district court.
First, as to the sufficiency of the evidence claim, the jury was entitled to resolve the issues of fact. It cannot be said that the evidence was insufficient to support the verdict and judgments. Second, as to the First Amendment claim, freedom of speech, freedom of the press, and freedom of assembly are fundamental rights. But, though fundamental, they are not, in their nature, absolute. These rights are not unbridled license to speak, publish, or assemble without any responsibility whatever. The First Amendment does not protect the speech, publication, or assembly in furtherance of a conspiracy to promote evasion of an act reasonably designed to protect the government against a clear, present, imminent, extremely serious danger of a substantive evil, here, destruction by a military force. But finally, the jury instruction issue merits discussion. The Supreme Court recently reviewed Keegan, the facts of which are fairly comparable to those presented here. In Keegan, pro-Nazi German Americans were prosecuted for counseling draft resistance to preserve their German spirit. The Supreme Court reversed the convictions in Keegan and approved the test case instruction, holding, "One with innocent motives who honestly believes a law is unconstitutional and, therefore, not obligatory, may well counsel that the law shall not be obeyed, that its command shall be resisted until a court shall have held it valid. But this is not knowingly counseling, stealthily and by guile, to evade its command." In light of Keegan, it is clear that the trial court erred in giving the instruction. The court should have instructed the jury to consider appellants' good faith and sincerity in bringing forth a test case to determine their status under the Act. The judgments convicting all 7 of the FPC leaders are severally reversed and the causes remanded.
On April 29, 1945, the 442nd Regiment, the all-Japanese American regiment, freed prisoners at the Dachau concentration camp. Germany surrendered on May 8, 1945, Japan on August 15. The Heart Mountain camp closed on November 10, 1945. The Heart Mountain draft resistors continued to serve their sentences until approximately a year after the war ended, and many months after the closure of Heart Mountain. One resistor never saw his freedom. 2 days before he was scheduled to be released, Fred Irie, who worked as an electrician in the prison power plant, was training the inmate who was to replace him. He touched an electrical switch, believing it had been disconnected. He was killed instantly.
On Christmas Eve, 1947, President Truman granted the draft resistors a full presidential pardon, restoring all their civil and political rights. On February 19, 1976, President Gerald Ford formally rescinded Executive Order 9066, and on August 10, 1988, the United States Congress enacted the Civil Liberties Act. On behalf of the nation, Congress thereby apologized for what it described as fundamental violations of basic civil liberties and constitutional rights of individuals of Japanese ancestry who were evacuated, relocated, and interned. Representatives Robert Matsui and Norman Mineta, who had been interned as children, co-sponsored the legislation. Senators Spark Matsunaga and Daniel Inouye, both members of the Fighting 442nd, pushed for the bill and the amendments in the Senate, which ultimately guaranteed funds for reparation payments to internment survivors beginning in October 1990.
What became of the defendants in the Heart Mountain trials? Jimmy Amaura may have escaped conviction, but his career as a newspaperman was over. He became a landscape gardener. Upon release from Leavenworth, Frank Emmy became a career civil servant. He worked for the Postal Service and the California State Employment Office. He also taught judo as an 8th degree black belt. In the late 1980s, he joined the Japanese American redress movement and publicly spoke out about his wartime civil disobedience. In 1993, he explained that
we could either tuck our tails between our legs like beaten dogs, or stand up like men and fight for justice.
Emmy passed away on December 1, 2010, at the age of 94. He was the last surviving leader of the FPC. Takeo Ishikawa, whose letter we read at the beginning of our program, passed away on June 5, 2016, at the age of 97.
All told, some 315 Japanese American men defied the draft in World War II. They were by far the minority, as the great majority answered their induction orders, reporting to fight for freedom overseas, even as they and their families were held in concentration camps. In some respects, those who said no were just as courageous as those who fought. They took a stand even as critics labeled them cowardly draft dodgers, and there were whispers that they just didn't want to get shot at. After the resistors were arrested, their families were ostracized and taunted by other camp residents. When the war ended, those who fought were welcomed home as heroes, while the resistors remained in prison until they completed their sentences and were then released as convicted felons. Later, when some of the resistors were drafted again to fight in the Korean War, they served willingly, for their rights had finally been clarified when President Truman granted them a pardon.
Most of the draft resistors were not willing to tell their stories for decades. For Japanese Americans, and for Americans generally, it was the heroism of the fighting 442nd that inspired, not the principles of the draft resistors. Only recently did the resistors begin to tell their story, and only recently have even the heroes of the 442nd acknowledged their contribution. In the foreword to Professor Muller's book about the draft resistors, Free to Die for Their Country, Senator Inouye, a member of the 442nd, described their experience as follows.
In this climate of hate, many felt the necessity of stepping forward to volunteer for service in the military to prove their loyalty to the United States. These men, for the most part, carried out their military obligations with much courage and honor. However, in this climate of hate, I believe that it took just as much courage and valor and patriotism to stand up to our government and say, "You are wrong." I am glad that there were some who had the courage to express some of the feelings that we who volunteered harbored deep in our souls.
This reenactment has provided another way for the draft resistors to get their story out. It was first performed in November 2012 at the annual conference of the National Asian Pacific American Bar Association. In June 2014, two of the original Heart Mountain draft resistors, Yoshito Kuramiya and Takashi Hoshizaki, participated in a presentation of this reenactment in Cody, Wyoming, just a few miles from the site of the Heart Mountain internment camp. They were both in their 90s, and Mr. Kuramiya played himself. Both are still alive today, and Mr. Hoshizaki is a board member of the Heart Mountain, Wyoming Foundation.
What about the others who played a role in the Heart Mountain trials? Samuel Menon continued to defend the rights of racial minorities, political dissidents, and the imprisoned. In 1948, when the United Nations General Assembly promulgated the Universal Declaration of Human Rights, Menon openly challenged the country to enforce the Universal Declaration at home before attempting to enforce it abroad. A.L. Weirin continued to represent Japanese and other clients in civil rights cases, practicing law until he suffered a heart attack in 1972. Carl Sackett, the United States Attorney for the District of Wyoming, left the office in 1949 and was replaced by his second chair at the mass trial, John Pickett.
Judge Goodman, the federal judge who found that the plight of the Japanese American draft resistors shocked the conscience, never lost his concern for the underdog. One of his law clerks recalled that the judge was once turned away from a southern resort hotel because he was Jewish. In a Yom Kippur sermon he delivered in a San Francisco temple in 1947, he made the following remarks.
We must all scrutinize both our Americanism and our faith. If we do that, we find a common obligation to cherish the cause of the oppressed or the disenfranchised. Gallantry and intrepidity in a just cause are the essence of strength. They command respect and admiration.
What can we take away from the story of the Heart Mountain draft resistors? It is a difficult tale to tell, for it surely suggests that the system doesn't always work as it should, despite the best efforts of dedicated individuals who years later still command respect and admiration. Perhaps the only true lesson is the need for vigilance. One of the children incarcerated at the Gila Relocation Center was Mishi Nishiura Weglin, who graduated from the camp high school in 1944 and was freed when Mount Holyoke College gave her a full scholarship. She wrote one of the earlier books about Americans' concentration camps, and in the preface, she stated her purpose as follows.
I have taken upon myself the task of piecing together what might be called the forgotten or ignored parts of the tapestry of these years. This I have done not to awaken disquieting memories or arouse negative feelings, but because of a clear responsibility. I feel for those whose honor was so wrongly impugned, many of whom died without vindication. And more significantly, I hope this uniquely American story will serve as a reminder to all those who cherish their liberties of the very fragility of their rights against the exploding passions of their more numerous fellow citizens, and as a warning that they who say it can never happen again are probably wrong.
Thank you, everyone, so much. I realized at the very beginning I forgot to thank a whole bunch of people, and I'm going to do that as the panelists are setting up. Of course, we want to thank the Dean's Office for the DOS Student Grant Fund. We also want to thank ITS, Events. We want to thank all of our co-sponsors, BALSA, JALSA, Lambda, MLSA, NALSA, SALSA, and HLS ACLU. And now we're going to do about 20 minutes of a Q&A. You can ask questions about this particular case or about the writing process, because all three, Judge Denny Chin here has been involved in writing this particular script, as has Judge Matsumoto and, of course, Ms. Kathy Chin. And we're going to walk around with mics if you have any questions. Judge Chin.
Thank you very much. Thanks to Harvard Law School and Harvard APALSA for inviting us here to do this again. I also want to thank Elliot, who has been the coordinator, has done a wonderful job of putting this all together. So we're going to talk just for a few minutes. The three of us are part of the team with the Asian American Bar Association of New York. And so we're just going to say a few words each, and then we'll open it up for questions from the audience. And I'm going to start with just a few words about the format, the reenactment of an historic case. Albany has been doing these for 11 years. We've now done 11 reenactments featuring cases of importance to the Asian American community. We've always tried to find historic cases that raise issues that are still important today. And this case certainly raises issues that have been very important in the last, well, ever since 9/11. And we unveil our programs at the NAPABA convention in November every year. But we encourage audiences to take our scripts and to go back to their communities and present them in their own communities. And sometimes the three of us will fly in and help out a bit. This one, the Heart Mountain presentation, is our second most popular presentation. Kathy and I have even performed it in Hawaii. And our most popular is the Vincent Chin one, which we did last year here at Harvard. The Vincent Chin program has been represented over 30 times, including in Switzerland. Kathy and I got to go to Switzerland and perform with an international cast. And one of the goals there was to promote diversity in the profession in Europe. And so it was nice that we were able to participate in that. But another important thing, and what we look for in these programs, in these cases, is stories, the stories about the people. And we are trying to help bring out those stories. And we want to introduce these cases to a new generation of Asian Americans and other Americans. It was because of this conference last year when the students, and Kathy Choi and others, encouraged me to come to Harvard and teach a seminar on Asian American legal history. And so this week, indeed, I started my seminar. It's capped at 25 students, but at one point we had 74 students on the wait list. And we also had about 9 undergraduates and graduate students who wanted to cross-register. So there really is a tremendous interest in this important area. I'm going to ask Kathy a question now. Kathy, your father was a Japanese American, a Nisei born in this country, who served in the United States Army. What do you think his reaction would have been to the Heart Mountain draft resistors? And in fact, what was your reaction when I came home one night and suggested this to you as a topic? Kathy and I are married, if you haven't gotten that.
Well, I think that my father would have been disappointed in me for wanting to present this story. And indeed, my first reaction when Denny suggested this particular story was to be somewhat disappointed in the idea. What I had been brought up with, and what I think my father believed, was the important story was that of the 442nd, the heroism of the Japanese Americans who, even though their relatives were incarcerated in concentration camps, went and died in Europe. That was the story that resonated with him. And that was the story that I grew up with. I had never heard of the Heart Mountain draft resistors, frankly. It was not a story that the Japanese American community was all that willing to talk about. So literally, I had never heard about it. But as we got more and more into the research and learned of the reaction of people like Senator Inoue, who finally recognized that, yeah, that's heroic too, I came around. And I think that ultimately my father, were he still alive, I think he would have come around too.
Judge Matsumoto, your parents were interned in the camps. Can you tell us where? Can you tell us a little bit about their experiences?
Well, my mother's family was interned in Topaz, Utah. She lived in San Francisco. She was one of 8 children born there, so she was a U.S. citizen. And as the script noted, my grandparents were not allowed to naturalize. There were laws against naturalizing folks from Asia. And so... My
seminar is studying all that right now.
Well, I'm sure it's a popular class, and I hope that you'll be able to take more students next semester. But in any event, they were originally placed at Tanforan Assembly Center. They were given the notice that they had to evacuate, and it's true. They could only take what they could carry. My grandfather had an art goods store. He lost everything. And they carried pots and pans and blankets. They were housed in stalls that were previously housing horses at the racetrack. There was manure in the stalls where they slept. They stuffed mattresses full of straw. Ultimately, they were carried by train to Topaz, Utah, which was a very remote part of the desert. And the barbed wire and guard towers were very much a part of their reality. My father's family was also from San Francisco. His dad had come at the turn of last century and had learned English in high school, went to the University of California, and was working with farmers in the Central Valley of California, shipping produce to the East Coast. He also lost his business. But because he knew so many folks in the Central Valley, he was able to relocate temporarily outside the coastal zone, and ultimately all Japanese and Japanese Americans were excluded from the state. So he ended up in Poston. And that was a very remote area in Utah. It was on an Indian reservation, and originally the tribal council that had the land was very resistant to having Japanese Americans incarcerated on their lands because they felt that it was wrong that they would be subject to some of the similar treatment. But my father, who was 19 at the time and a senior at UC Berkeley, tried very hard to apply to colleges and was ultimately released to go and continue his undergraduate and graduate education. My mother remained in the camp for the duration of the war.
And you're now a federal judge. So what, if anything, does that tell us about our system?
Well, my parents were always very open about the experience, and their message to us was, be aware that this happened and be vigilant that it not happen again. My father was a professor in North Carolina, which at the time was very segregated, and my mother made sure that we were aware that these water fountains that were designated colored were fountains that we should drink out of to understand and appreciate that we were people of color. And on the other hand, she said, drink out of the white fountains because you have the right to do it. You're no different. Everybody should have equal rights. So they tried to instill this sense of equality and equal opportunity in us. And it wasn't until we moved back to California, ironically, that we had trouble buying homes in certain neighborhoods. We were told, you can't buy in this neighborhood. And this is years later, after the war. But I think that the hostility against Asian Americans, at least in the early 60s, was still very prevalent.
And back to Kathy. The script mentions a reenactment in Cody, Wyoming, and two of the original draft resistors came. So you and I were there. Would you tell us what it was like?
It was an unusual experience, but it was great. I mean, these two elderly gentlemen, they were both amazing. We originally did a phone rehearsal with both of them, and Tak was Takeo Ishikawa. And just listening to him read those words from the letter, I was in tears. Sitting in my office, just listening on the phone, it was amazing to hear them reciting these words that meant so much to them. And then, we were out in Cody, Wyoming to do this reenactment as part of a conference. Was the National Coalition on Racial and Ethnic Fairness in the Courts. And this reenactment was put in the high school gym in Cody, Wyoming. And as I understand it, our competition that night in terms of entertainment was they were putting on the Music Man on the other side of town. Nevertheless, there were lots of people who came to our little reenactment. There were kids running around in the back. And it was well received, and it was amazing that these gentlemen were willing to come and participate. Tak, as it turns out, was so excited by the whole thing that he forgot to drink enough water during the day and ended up going to the emergency room right before we started. But he was fine and showed up at the conference the next day. There was no keeping that man down.
And Mr. Tamiya was really feisty, as I recall, still, even though he was in his mid-90s.
Yeah, he's the one who was in the picture. If you notice the picture of us standing there with an older gentleman, that was Mr. Tamiya. And his wife was even feistier. So they were quite a couple.
As it should be.
Yes.
And with that, we'll take some questions, if there are any questions from the audience.
I think we have time for maybe 3 questions or so.
Questions?
Hi, thank you so much for doing this. I think today we all recognize Japanese internment as one of the most egregious scars in American history, but I'm wondering how you think about your roles as judges, considering that it was upheld and affirmed in the courts and justified by judges who work for the government.
Well, you say it's one of the most egregious scars. There are many people who think that those decisions are still good law. They've never been actually overturned, and they're not cited very often. In the 80s, the convictions were set aside in the quorum nobis cases, but on grounds of misconduct, not on the grounds that military necessity is sufficient to justify putting people in concentration camps without due process. Like all these things, they're part of what we've studied and who we are, and we're interested in these things. If we get a case, will we be in some way unduly influenced by our experiences studying these cases? I don't think so. I hope not. Hopefully we will look at the cases on the facts and on the law and decide them. We moderated a panel 3 judges, and I asked the question, do you think Korematsu was correctly decided or wrongly decided? 2 out of 3 thought it was correctly decided, and they were Asian American judges. So who knows? It's a complicated question.
You know, I think that we've heard rumblings about the incarceration as recently as the last 3 or 4 years. I think the mayor of Roanoke, Virginia, talked about it with approval as something that happened in our past, and this came up, I think, in the context of the travel orders, and since 9/11, certainly there has been, understandably, some reaction, strong reaction to the attack on our country, but the broad strokes that some were calling for to round up Muslims or to punish Muslims or to ban them, I think is something that, you know, we should be aware of given our history and think about the need for due process and individualized determinations. I have not had a case. There are some cases pending in my court. I would not be able to comment because each case has to rise or fall on the merits, the factual record. But these are difficult times, certainly, for many people. And our immigration history is one that is very complicated. And I think we're sorting through, as the government sorts through a revision of the laws, our jobs as judges would be to review if there are challenges and to decide cases on the record and on the law as it exists.
Next question.
Kathy, did you have a question in the front?
I think there was one.
Thank you so much again. I think one part of this particular reenactment that really struck me was Judge Goodman and how he wrote that opinion with the car idling, and then the later statement that he made about being critical of your patriotism and your own faith. And I just wondered, in the research process, how you found his story and what your reactions were to reading about this judge.
Well, I mean, as part of the research, we did look into cases similar to the Heart Mountain experience. And as you noticed in the reenactment, we mentioned several of these cases. And during the course of that research, his story stood out because he was, you know, the only judge who threw those charges out. And it was indeed, it's a great story. I mean, the idea that at some risk, at some personal risk, he was willing to stand up for these Japanese Americans. I mean, it's a powerful story, and it's sort of one of the nice things that comes out of what's essentially a sad tale. I mean, there were people who were willing to stand up and help the Japanese Americans at some personal risk. The story of the lawyers who stood up for the draft resistors. I mean, these were remarkable lawyers, and you know, they put themselves on the line to do these cases. Lawyers have a very important role in situations like this. It's certainly true that Korematsu is still good law, but there were several heroic teams of young lawyers who undertook the Coram Nobis cases in order to get the convictions of those individuals overturned. And somebody who was on one of those teams is in the audience right now, Karen, who is going to be your keynote speaker tonight. Lawyers can do wonderful things. And it involves sometimes, you know, great personal sacrifice. But your education as lawyers put you in a position to do good and to help people. And I think that's one of the stories that comes out of a reenactment like this.
One of the reenactments that Judge Chin and Kathy drafted and has been performed is the story of James Meredith and his effort to gain admission. And to hear about Constance Baker Motley and her courage in going down to the Deep South and facing, you know, Klansmen and, you know, violence, threats of violence. Justice Thurgood Marshall, who was head of the NAACP at the time, sent her down because he thought she would have a more effective and a less onerous time in some ways than
an African-American male would in the Deep South. But she had a lot of challenges, and it took great courage for her to go really unaccompanied to fight that case.
I think his Thurgood Marshall's exact words were, I'm going to send you down because all the white men in the Deep South had black mammies. And he thought that she would be a little bit safer. But apart from that, by that point, she had been involved in most of the big cases that they had brought. And one of the interesting things in researching that one, and Kathy did most of the work on it, was when she appeared in court, it was a spectacle, and all the blacks would come and watch, because here was a black woman standing up to the white establishment. And in terms of the issue of judges having an effect, there were a lot of judges down there who were still resistant. This was 7 years after Brown versus Board of Education. There were a lot of federal judges down there who were not going to implement Brown versus Board of Education. So it was fascinating to do that script. We're going to do it again in a couple of weeks in New York, and we're doing it with the Asian American Bar Association, the Metropolitan Black Bar Association, and the New York City Bar Association. So another good thing about this is bringing different groups together to work on something.
Thank you very much. I think we have time for one more question, because I'm told that a lot of you have someplace important to be at 6 p.m. So.
Thank you so much for taking the time to be here today and to come down and really put a human face to the Japanese internment. I'm Yonsei. I'm fourth-generation Japanese American. My grandmother was interned for the entirety of the war, and my grandfather was interned briefly before being told to go east. He moved to the Midwest and later joined the Army as a lieutenant colonel and served in the Korean War as an intelligence officer. My question is mostly that as a body, Asian Pacific Americans are generally seen as apolitical and as assimilating. Not to discount the military service of any of my generation or my ancestry, but a lot of times what the Japanese adhere to is shikare ga nai. It's put your head down, it cannot be helped. Assimilate, serve, do what you need to do to get through it. And so the No-No Boys and the resistors are kind of an unusual time in history for Asian Pacific Americans in that there was a period of active resistance from a culture and a people that don't tend to be those actors. So my question is, what can we take away from that today in an era when obviously resistance is an important part of our political atmosphere, of our political dialogue and our political language, because there are many ways that none of us would feel comfortable assimilating with current practices. So what lessons can we take from the resistors at Heart Mountain and the No-No Boys to carry forth today in our, both individually and in our roles as APA attorneys?
Well, you started off by talking about the stereotype of submissive Asian Americans. I'm not sure that that is so. When you go back and you look, Asian Americans were challenging racist laws from the very beginning. They were bringing many habeas corpus petitions. They were able to hire the finest lawyers. They were able to hire legal dream teams, in part because they had family associations, merchant associations, and they would chip in their money together. They were bringing impact litigation before there was such a term as impact litigation. So I think, and the Japanese during, there are all these cases challenging the Oyama case, alien land law, the internment cases. So there are lots of these cases. And I think one thing that people can do today is to remember these cases and how our predecessors and ancestors did not hesitate to stand up for their rights and to try and get relief from the courts when appropriate.
And Kathy's point, I think, is well taken. As lawyers or soon to become lawyers, there are a lot of opportunities where you can make a difference, not just in your communities, but nationwide. One thing my mother said to me oftentimes is there weren't that many lawyers to stand up and challenge what was happening. And she was very impressed during the redress movement that so many young lawyers in this third generation of Japanese Americans had come together and said, we need to fix this problem. Let's vacate these convictions. Let's seek redress. Let's get the government to acknowledge the wrongdoing and issue a formal apology. So, you know, I think history, there is a movement that is afoot called, you know, don't let history rewrite itself, or don't rewrite history, or Kathy's got the pen, excuse me, it's stop repeating history. Repeating history,
Yep.
yes. So, you know, there are opportunities, and there are more Asian American lawyers entering the pipeline, and whether you're in private practice and can seek out pro bono opportunities, or whether you go into organizations, there are challenges and opportunities to stand up for our Constitution.
Yep, time to stand up and speak out.
Well, with that, we'll conclude this session. Thank you, everyone. I'd like to thank Judge Denny Chin, Judge Kiyo Matsumoto, and Ms. Kathy Chin, and of course the entire cast. Thank you, Dean Sells, Professor Reynolds, Ishen, Professor Mark Wu. I have an important announcement. I'm told that there are a lot of coats still at WCC, so if you don't have your coat here with you for the conference attendees, please go back and get them. Thank you very much.